now turn it over to our managing attorney of the Orlando area office in Winter Springs. This is our board certified specialist in condominium and plan development law. There aren't many of them in the state. You have one of them today. This is Alan Schwartzseid.
All right.
Alan.
Thank you, Jeff. So again, my name is Alan Schwartzseid. I am the managing partner of the Orlando office of K. Bender Rembaum. Just a little bit about the firm. We do nothing except represent community associations. It's 90+%, if not more, of our business model, so to speak. So this is literally what we do, and it's almost all we do. We're not a real estate firm or a family law firm that just happened to throw this area of law onto our website. This is what we do, period. So with that said, as Jeff mentioned, I am a board certified specialist in this area of law. I'm one of 8 within the firm. We've also got an attorney who's board certified in construction law on staff. So if you've got those types of issues come up, we don't try to be a start to finish firm for everything that comes up, but we do try to be, and we really are a start to finish firm for everything that comes up for a condo, an HOA, or a co-op in the state of Florida. Adding to that, we do have a response time that I think is on par or better than 99% of firms in this industry. I make sure that anything that comes in for a client of my office is going to receive a response or an acknowledgement within 1 business day. Can't promise you will get you the answer or the work will be done within that quick amount of time, but you're not going to sit around for 2-3 weeks like I hear about other firms waiting to hear if we even got your question, and then another 3-4 weeks before you actually get the answer. So without further ado, thank you for listening to my little 30-second elevator pitch. And we are here for the 2025 legal update. My information, in case you need me, is usually on this screen. Up there it is, right in the middle. I don't know how I missed that, but my name, my email address is as@kbrlegal.com. I also post on LinkedIn almost every day. Feel welcome to follow there if you want some additional tips that you may or may not get in here, because frankly, that's just stuff that comes up on a daily basis that I think, well, that might be helpful information. So the name that you will look for is the one that's listed here, because you won't remember how to spell it, and that's just fine.
I'm going to
Moving
mention
forward,
one other thing, Alan,
go
real
ahead,
quick.
Jeff. I'm sorry.
And folks, you will have access to download and save the slides at the end of the webinar after you fill out the evaluation that we mentioned a little bit earlier. So you don't, you're welcome to take notes, but you don't have to take tremendously detailed notes, because you will have access to these slides after the webinar, after we place the evaluation link into the chat area later. Back to you, sir.
All right, thanks, Jeff. So yeah, feel free to just sit and listen. Another thing to point out that this is being recorded and will be posted on our website. So if you miss anything, you don't need to send something in the Q&A asking me to go back, because frankly, I won't be doing it anyway. Moving forward, okay, managers and management firms that represent community associations are the first thing we're going to deal with today. There are a couple changes, and understand when we say a legal update, the purpose of this class is essentially to give you an update on what the heck the legislature and the judiciary did to us over the last year that's going to apply for this year going forward. So most of this stuff kicked in on July 1st. I'm not going to reiterate that every time. I'm also not going to state the statutes or the bill numbers that this pertains to. You'll see that at the top left of all of our slides here. So I don't need to waste your time with that either. Now, when it comes to management firms, one requirement that was added is that the manager needs to attend at least 1 member or board meeting every single year. It doesn't say that they are required to attend in person. It just says they must attend. This only applies to HOAs. It doesn't apply to condos or co-ops yet. I'd be surprised if within the next year or two, those management firms are not required to do the same thing with respect to condos and co-ops. Now, keep in mind, when we say management firms, just so you understand, because I do presume that anyone that's attending a legal update has at least a basic understanding and has done maybe a board certification class or something of that nature. But a management firm is a company that gets hired to basically do the business of the association at the direction of the board. So these are people that are not running your operation, but they are doing a lot of the tasks that are involved in running your operation. The board and the members are still going to be the ones that make all the decisions. Moving back into the changes, again, this is an HOA only change. And we will kind of flip-flop back and forth. So condos don't sit there and say, oh, he didn't touch anything for the first hour that means anything to us. Don't worry, we'll get to you too. You kind of need to put like your office hours, like a teacher would put, and your contact information directly on the website. This needs to be accessible to all the members. Now, this presumes that you have a website. Usually, the management firm will have one, even if the association doesn't. And websites are another thing we'll get to later on. But understand that a summary of the duties that that manager is responsible for, where they can be found, how they can be communicated with, all of this information is now going to need to go on the website, and it needs to be provided otherwise to the members and the residents of your community if there is no website. Now, again, we say it needs to be posted on the website or the app. Now, I've seen 3 communities in my career so far that use an app instead of a website. Some of them do, and that is okay in lieu of having a website. My suggestion, if you're already building a website, there are plenty of companies that will build an app that basically just puts that website on your phone. That's probably going to be the easier way to do it, because let's be realistic, we're in Florida and there is an elderly population here that will not understand how to use your app. There's also trying to get it onto various different operating systems that are on people's phones. That's just a practical tip. Moving on to the required updates if that information changes. Now, going back probably 3 minutes when I made the last comment on what the changes were, if your manager is someone new, so you swap out and use a different manager or a different management firm. If you have different office hours, different ways to contact this person, the number or the extension changes, all of that needs to be changed on the website within 14 business days after the actual information is changed. So if you have a new manager coming in, the old one probably won't be willing to put that new manager's information up, but they should be starting to set up this information ASAP. The contract with the management firm is also available. This is separate and apart from any records inspection request. So this is a responsibility of the management firm itself and the individual managers. This is not an association responsibility. There's nothing that I see in the HOA Act. And again, this is an HOA only issue, but there's nothing I see in the HOA Act that says the association is responsible for the manager providing this information. Now, if an owner requests to inspect the records that include the management agreement, that would be an association responsibility separately. But this is the manager being requested needs to provide a copy of that contract with the association. There's no specific timeline in the statute. I anticipate that the same 10 business days that's provided by Florida law is going to be applied by most judges, but that doesn't mean that I'm right. So my suggestion is that the manager keep a copy of this accessible, probably right on their desktop or in some, remotely accessible folder, and it just gets forwarded via email or printed when someone requests it. There are new continuing educational requirement for managers. DBPR can require, that doesn't mean they did, by the way. So CAMs that are listening today, you're going to need to follow up and figure out what you're responsible for. But the DBPR can require no more than 10 hours of continuing education annually. That includes every other year, each CAM completing at least 5 hours of education pertaining to HOAs, 3 relating to record keeping. Again, this is HOA only. Returning of records, CAM firms and management firms that are no longer working with the association now have 20 business days after termination to return all of these records or property to the association, or 20 business days from receipt of a written request. So if you've got a contract that's terminating, but it doesn't terminate for 2 months, and you're having a transfer to a new management firm who needs those records, my suggestion is send out a request for the records, and the management firm should produce them within 20 business days after they receive that request. That 20 business days may be even before termination, so that you don't have an interruption, and I'm dealing with one right now. You don't have an interruption in service because the new management company can't get records from the old one. The manager can complete records so that they can complete financial reports or statements for up to 20 business days, But if the association has those records and refuses to provide them, the CAM's off the hook, meaning, well, you're no longer working with us, so we're not providing you anything, but the management firm was trying to provide the financials. If they don't have the ability to do it, they can't do it, and they're not required to. The penalty for failure to comply with this statute is kind of like the records inspection. I call it the $500 gift. If you don't provide this within the 20 business days provided by law, then starting on business day 21, there's a much larger gift that the management firm is giving the association. It's $1,000 a day up to 10 business days, assessed beginning on business day 21 after that request was received by the management firm. So we're talking about up to 10 grand for violation of this new statute. I would strongly recommend that management firms comply, and in reality, don't you want to be done and out if you're done and out? Moving on. Financial interest disclosures. So this is really more of a conflict of interest statute pertaining to managers. It's pretty much the same as the statutory conflict of interest with respect to directors, but it's now codified not only in the HOA and condo and co-op acts, but now also in section 468.4335, which is pertaining to the management companies themselves. The conflicts of interest, I won't read through because, again, it's pretty much the exact same thing. The only difference is instead of it being a director or officer that has the conflict, it's the manager here. So understand if you are getting bids from a CAM that exceed $2,500 to do something other than managing the association. Now, I said managing the association. This includes, for example, we work with a couple management firms that also do individual property management. They'll do the rentals. If that's within the community and it's the association that owns that property, then and the bid exceeds $2,500, then there is a different requirement that applies. You need to solicit multiple bids from other third-party providers. That doesn't mean you can't still go with that management firm because you know them, you like them, you respect them, and you know they'll do a good job for you because you're already working with them. But it does mean that you'll have to get bids if that bid from the management firm is going to be more than $2,500. That could also be that they have maintenance people on staff or contractors on staff. We work with another firm that's got great contractors on staff to do certain restoration work and things of that nature. You would just need other bids. It's not that you can't work with them. Whenever you're getting bids, understand it's not that you have to accept the lowest bid or that you're precluded from accepting any particular bid. It's you accept the one that you think is going to be best for your community. The difference here is that there are certain disclosures required. And I'll not really read this because it's pretty much the exact same thing as what you would need to do if it was a director or officer. You need 2/3 of all the directors, and then the existence of the conflict needs to be disclosed at the next meeting of the membership. The contract can be canceled by a majority of all members. I think it's members present at that meeting. Let's see. Oh, it's 20% of the voting interest. Sorry, this is a new one, so I got that one wrong, to be candid. But it's if there is at least 20% of the voting interest in the association vote in favor of termination, that contract can be terminated. And the only thing that that management firm or that arm of the management firm will be entitled to, or that manager will be entitled to, in exchange for doing the work, is the work that was actually done up through the date of termination. So if you've dealt with bulk contracts for internet and video, this is the same type of termination where it only goes through the date of termination, regardless of any termination fees, anything that should have gone through the end of the year, for example, or an ongoing term. You don't have to pay any of those ongoing fees if it's terminated by the members in this way. Now, if there's no disclosure of that conflict, for example, one of those management firms is managing an individual property and you don't disclose that there's a connection between the management firm and the property manager as opposed to the community manager, then the association can cancel the entire management contract. And again, only liable for the services provided up through the time of cancellation. So failing to disclose the conflict can also lead to disciplinary proceedings by the DBPR against the individual manager and or the management firm. Bottom line, if you're looking to work with a management firm that is providing services other than community management, that's okay. Just make sure you get the bids, you make the disclosures that are required, and then you move along nicely and take care of what needs to be done. My recommendation is just have your attorney give you guidance as to how to properly walk through this procedure. So we talked about that. We talked relative. I won't go through. DBPR is also deciding, apparently, or the statutes have now decided that anyone that's been licensed as a CAM for more than 10 years, or at least 10 years, without any dings on their record, so to speak, does not have to take any education. I think that's a little bit ridiculous because you'll see how much information is contained in this class. Think about if you haven't taken the 2-hour class we've taught pretty much every year with 2 hours worth of changes. Let's say you haven't done it for 3 to 4 years. You're losing 8 hours worth of material that manager doesn't necessarily have because they haven't taken an educational class. And keep in mind, this is not the only class that, in my opinion, they should be taking. So I think this is, frankly, bad legislation. It may have been a situation because it does sunset on January 1st, 2026. It frankly may be that one legislator happens to have a CAM license or some other licensure and didn't want to have to take these classes for the end of their tenure as a CAM or, before they retire. So bottom line, this sunsets unless it is readopted in January 2026. And frankly, as much as I wish that there was not such an administrative burden sometimes on property and community managers, this is one that I think there should be that burden to make sure, just like other lawyers, engineers, architects, other professionals, doctors, make sure that you're actually up to date on the status of how things are supposed to be done, because that is literally your job. All right, moving on to, and we will talk about managers a little bit more later, but 90% of the material is now directed towards the board members. So thank you for bearing with me for almost 20 minutes, but we're going to move into I won't call it the real material, but the statutory updates for condos and HOAs directly. There are some changes that were made to official records, some changes that were made to website requirements. So let's just dive in. For an association with a condo managing 25 or more units that doesn't contain timeshare units will now need to have a website that needs to contain all the information that was required by the statute before and what was added this year by January 1st, 2026. Let me reiterate that. Okay, it used to be that there was a requirement if you had 150 or more units in your condominium in Florida, you had to have a website. That kicked in, I believe it was about 2 years ago, 3 years ago. This is expanding the requirement to communities that are a lot smaller. So again, if you have 25 units or more and you are in a condo, you will need to have a website by January 1st, 2026. Now, that sounds like a ton of time to most people, and frankly, it is. But when there are maybe 10 good companies in all of Florida that are doing this work, you don't have to use someone in Florida, but when there are certain companies that are really focusing on this, and maybe you should be the ones you're using, unless you're using a management firm that offers this service, which, by the way, if you're managed by a management company, contact them because you'll probably save a ton of time and money having them do this for you because they're probably already doing it. But if you need to go out and have a website created, again, you've got until the end of next year to do it if you are in one of those condos between 25 and 149 units. Things that need to go in the official records were also clarified. Now, the important part that I'm mentioning here is not just the threshold for when you need a website, but how those documents that are in your official records are hosted. Now, for those that don't know what the official records are, it's pretty much every written item that pertains to the operation of your condo, your HOA, your co-op, whatever it may be. So the official records are the ones where you are maintaining those in some way, shape, or form. You're literally putting them somewhere. It used to be that you could keep them just thrown in boxes, disorganized. That's all changing this year. So the email addresses and fax numbers is a major issue that I come across. If you've got email addresses, you've got fax numbers, you've got other addresses that are not being used for official notices of the association. For example, you got something and someone agreed to accept email blasts, but your annual meeting notice is not something that they agreed to accept by that email address. That email address is not an official record of the association, and no one other than the board is entitled to that information, other than maybe the manager, the attorney. But none of the other members can do a records inspection request, ask to see that email address or a list of email addresses, and get access to it. So the only email addresses and fax numbers and mailing addresses that are to be produced by the association are the ones that have been designated specifically for the association to send official notices. And to be clear, an e-blast may be officially coming from the board, from the association, but it is not an official notice, meaning it's not a meeting notice, it's not a budget, it's not something else that is required by law. Those email blasts are just to help the members understand what's going on. The association does have an obligation to ensure that that information is only used for the business operation of the association. It can't be sold or shared with outside parties when you don't get it for purposes of official notices. Now, if that information is included, the association needs to redact it before the information is disseminated. So if someone does an official records inspection request and you're producing documents that have those email addresses or fax numbers on them, you do have a legal obligation now to redact it and get it out of the record, or at least not produce it to someone who's not entitled to see it. Now, the good news, the association is not liable for inadvertent disclosures of that information. All right. The official records now also include, and I don't know how it's feasible that they didn't before when there's a catch-all that talks about all other records pertaining to the operation of the association, but I digress. The records now officially include all invoices, transaction receipts, deposit slips, essentially anything that's going to show how and what was spent by the association or received by the association, copies of building permits, and board member education certificates. We'll get into that later. Now, I mentioned earlier the manner that you're maintaining the official records. You are now legally obligated to keep those records organized. The days of saying, here's the boxes at your records inspection request, good luck, have a nice day, that is no longer an option. Those days are over. Okay, if the records are not maintained properly, you are not complying with the statute. And when I say properly, I mean in an organized fashion that basically helps an owner find what they're looking for. Now, if those records are lost, destroyed, or otherwise available, and all of this is condo, by the way. So HOA people, just bear with me. We'll get to you shortly. The obligation to maintain those records includes a good faith obligation to find them if reasonably possible. So you can no longer say, well, John Smith stole that. You need to actually pursue John Smith to get the record back. So it is now the official obligation of the association to actually get these records. Now, good news for once, if the documents are posted on the association website or available for download somewhere, it is now officially the law in Florida that the association's appropriate response to a records inspection request for a condo is go on the website, it's all there. Now, of course, you need to make sure that the information is actually all there. If it's not, then you have a problem because you haven't produced those records. But if all records that that owner, that requestor is authorized to see are on the website, it is an appropriate response and a complete response other than the new checklist requirement to say, have at it. Go to the website, it's all there. Go to the portal, it's all on the portal. This is going to be extremely helpful for condos that do have a website and are hosting all their records there, because your records inspection policy, which is one of the ones that I think every community association in Florida should have, is essentially going to be, we're authorized to send these records however we want, whether it's here's the, you have the link. If you don't have a login, let us know. Our obligation is complete. That's sufficient now. It wasn't before under Florida law. So this is a great change from my perspective. Thank you, legislature. You got one right. Again, I mentioned this checklist. In response to a written request, the association also needs to produce a checklist of all records that were made available and were not made available for inspection and copying. So that is part of your response now in a condo. That checklist also needs to identify what wasn't made available. Now, my perspective, um, there are different perspectives on this. The law is not clear. The legislature just chose not to be extremely clear on this particular issue. The statute doesn't say whether the obligation of the association is to maintain a list of every single record it has and check off the ones that were versus were not provided, or if a list of categories, which frankly you can copy and paste from the statute, is sufficient. My perspective is, unless you want to be very, very cautious, the general checklist of categories is probably sufficient until DBPR tells us otherwise, and they have not as of now, to my knowledge. Failing to produce records. This is a separate section. Repeatedly, meaning twice or more within a 12-month period, is now a misdemeanor. Now, this has to be knowingly, willfully, and repeatedly failing to provide. It's a misdemeanor of the second degree. The question is, who failed to provide the records if the manager is the one responsible for responding to this request? So from my perspective, if you're manager and if you are a managed community and your manager is responsible, this is not probably going to be a director's responsibility unless the director is actively telling the manager, don't produce that. Usually that's only going to happen because there's something to hide, because it's privileged information, which you would not be convicted of that misdemeanor, in my opinion, because you had no obligation to produce that record, or because they're trying to hide something that they don't want to get out. Usually, if someone does not produce something, it's either because they don't understand their obligation to produce it and didn't ask for legal guidance, or it is something that actually is not subject to production, because there's an entire list of items in the records inspection statutes for condos and HOAs that are exempt from production in this way. Now, if you fail to provide these records with the intent to avoid or escape detection, arrest, etc., that, instead of being a misdemeanor, and it only has to happen once here, that is a felony of the third degree. Basically, where you're hiding the ball by saying you can't have these records because they would incriminate me further, that is now a felony of the third degree. It's essentially obstruction of justice is the way that I'll describe it. And that's not 100% accurate, but it's pretty much what the statutes are describing here. Accounting records, anyone who intentionally destroys or defaces accounting records, same thing here. It's a misdemeanor of the first degree. Basically, if you're trying to get away with something, it may be worse. If it's just that you are destroying or defacing records or failing to create them with the intent of causing harm to the association or a member, you will be facing a misdemeanor of the first degree if someone finds out. So basically, don't do it. All right, moving on to HOA records. Told you guys we'd get here soon. The association is obligated to maintain all of these records for at least 7 years. There's a whole list here. Now, keep in mind in condos, this wasn't a change this year. I think it was last year. Condos need to keep most records, except for the ones that are specified, indefinitely, or a lot of records indefinitely. So understand there is a distinction between how and for how long a condo versus an HOA needs to maintain these records. I won't go through the list because frankly, we've got the catch-all that's still here. I think we're probably going to get here in a minute. Yep, here we are. I'm highlighting, hopefully you can see that. All other written records of the association not specifically included in the section of the statutes which are related to the operation of the association. That's a catch-all. Now, the things that you'll need to keep for a shorter time, meaning you don't have to keep them for 7 years, are your ballots, sign-in sheets, voting proxies, and other documents regarding voting by members, as well as bids are also a 1-year retention period. Now, keep in mind, before you destroy anything, the statute now also requires, and this is one other policy that I think every community in Florida should have, and apparently so does the legislature, is a records retention policy, meaning how are we going to maintain our records? How long are we going to maintain them? When are we going to destroy them? And how are we going to destroy them? And basically outlining what are we supposed to be doing with these records when they're not being asked for. Now, I mentioned HOAs will also need to have a website now. The criterion that the legislature has adopted is 100 or more parcels. So I actually had a question about lots versus parcels over the last week. Just understand, if you're not sure if a lot is a parcel for purposes of your community, ask your attorney, make sure that you're complying with this. And by the way, do it today, because you've only got 2 weeks to create this website if you haven't already. Actually, less than 2 weeks now, because it must be created by January 1st, 2025, if you are in an HOA with 100 or more parcels. Now, you need to create, and this is already in place for condos, which is why it's not mentioned for condos here, but in an HOA, this website needs to be password protected other than the information that is publicly available to everyone. So, for example, your governing documents don't need to be behind login credentials, but everything else needs to be protected from public view. Even if the members are entitled to see it, that doesn't mean everyone in the world is. So the bottom line is, make sure that you're either working with your management company or working with a vendor to create all of this, if you have the obligation to create it. Now, for those of you who are in smaller communities and don't have that obligation, two things. One, that doesn't mean that the legislature won't do an HOA land, what it's done in condo land this year, and say if you've got 5 or more parcels, you're now required to have a website by next year or something similar. So don't think that you're getting away with murder here. The bottom line is, it's entirely feasible that you might have to have that website as soon as 2026, for all we know. Because my favorite professor in law school used to say, nothing is safe when the legislature is in session, and we've certainly seen that over the last few years. So the other thing that I'll point out is, we're about to talk about a couple requirements of these websites. If you are not required to have a website, you are technically not required to maintain a website in accordance with these requirements. Meaning, if you have one, but you're less than 100 lots, technically everything I'm about to say, you're not required to do. My recommendation, if you're an HOA and you have a website, comply with these requirements to make it easier for you to operate the business of the association. Because the bottom line is, 99% of what's in these website requirements are things you would otherwise have to do that wouldn't be digital. And if you can say that information's right there, that makes everyone's life easier, and especially your managers, which also means that the association gets charged less for management services. All right. You also need to make sure that anything that is not subject to disclosure, including to the members, is kept separate. So that you might have separate login credentials for the board versus the members, or separate login access that is granted to the members versus the owners. Same thing applies to a condo. The protected information that we're talking about, almost all of this is what is going to be exempted from production in a records inspection request context. So I'm not going to go through the list, but one of the most important ones here is, you do not need to divulge attorney-client privilege discussions, meaning discussions with your attorney regarding potential or ongoing litigation. So just understand all of this information, and I won't go through it because it's already the same stuff that was exempt from production before, doesn't need to go on your website. All right, we talked about the requirements. There are records that do need to go on your website if you're required to have one. And it's basically your governing documents, your rules and regulations and policies, your architectural criteria, a list of all contracts or copies of the contracts themselves that are current and ongoing, the annual budget and proposed budget that's going to be considered, the financial reports and income or expense statements that are going to be considered at a meeting, current insurance policies, the board certifications that I said we'll talk about later, all contracts between the association and any director, corporation, etc., basically conflict documents, any contracts or documents regarding a conflict of interest. And that's basically what needs to be posted on the website behind login credentials. Now, again, if something is already recorded in the county records, that doesn't need to be behind login credentials. And frankly, it may be more helpful to not have it behind login credentials so that less people are asking the board or the management for copies. But that is a board decision to make. Member meetings in an HOA, you now need to post notice of any scheduled member meeting at least 14 days before the meeting on your website. There needs to be a separate location on the homepage where you are posting these notices, or at least a link on the homepage that is conspicuously visible and linked from the homepage that says notices. And that's going to include your notices and agendas for upcoming meetings, possibly past meetings as well. Now, if a document's going to be considered, so for example, you're considering moving over to work with our firm, and for some reason that is a member decision. I can't imagine why it would be. But if it were, that document, the contract itself, would need to be posted on the website at least 7 days before that meeting. Now, again, this is a 14-day notice of a member meeting. Same requirements will apply if you're considering special assessments, even though that's a board meeting. Same requirements will apply if you're considering architectural modifications or modifications to the use of the lots. That's also a 14-day board meeting notice where you'll have to post the agenda and the contract or the document that's being considered at least 7 days before the meeting. This all goes on the website. And again, you don't have to have a website unless you've got at least 100 lots. If you don't have those 100 lots in your community, that doesn't mean that you shouldn't have a website anyway, just to make your life and everyone else's lives easier. But you're not required. Board meetings, same requirement. The only difference is, unless it's one of those two exceptions that I mentioned before, for board meetings, you only need to post that notice and 48 hours in advance of the board meeting, along with the agenda and any document that's being considered at the meeting. I talked about the records retention policy. That really should be something that everyone was supposed to have by July 1st. If your attorney is not working with you on it and you're not happy with your attorney, feel free to reach out to me. If you're happy with your attorney, then work with them on it. Law enforcement subpoenas is yet another issue that I don't know why we needed this law, but it's here now in an HOA. And I presume that this will come into play in condos at some point as well. You need to assist law enforcement agencies that send you a subpoena by producing any records they ask for within 5 business days after you get that subpoena. Okay, unless there's a different timeline specified in the subpoena itself. Now, this is basically saying, well, there's a criminal investigation. We need your information right away, and you need to produce it. This doesn't apply to all civil cases. It doesn't apply to all criminal cases. It's only if the subpoena is coming from a law enforcement agency. So understand there is a major distinction there. Okay, moving on to board certification and continuing ed requirements. This is what I was mentioning earlier with the certificates. Within 90 days after being elected or appointed to the board, there's been a requirement in place for a long time, several years now, that you either take a class, a board certification class with someone like our firm that teaches it regularly. I think we probably have a condo and an HOA one roughly once a month. Or you sign a piece of paper that says, yeah, I'll do my best, and I'm going to try and read through the governing documents and Florida statutes that apply to our community. Now, the reality is no one reads the governing documents. The people that do read through them don't understand them, including your attorney most of the time, because they're not really drafted in a way that's meant for your particular community. They're meant to do the bare minimum where the developer can get away with it. And that's not an indictment against any developer or any developer counsel. It's just that these documents are reused over and over and over, whether it applies to the way that your community is being developed or not most of the time. So there are often changes that need to be made. Working on amendments is something that I do regularly for that very reason. But bottom line, you now need to do both. Okay, so you need to take the class and you need to sign that certificate within 90 days after being elected and get that certificate to your secretary, or if you are managed by a community management firm, to your manager. That certification in a condo context is valid for 7 years. Now, that doesn't really make much sense to me because you're now going to be required to be off the board after 8 years. So, okay, we were allowed to get away with this for 7 years, and now I have to take it again for a 1-year term. Doesn't make a whole lot of sense, but that's what the legislature's done so far. Now, when I say 7 years, I mean so long as the director serves without dropping off the board. So when people talk about the little trick to get away with serving for more than an 8-year term in a condo, Dropping off the board now will mean that you need to take a new 4-hour educational course. Now, again, our firm offers this for free online, just like this course. Um, just understand if you drop off the board, now this doesn't apply to suspensions from the board, but if you are actually off completely or you abandon your seat on the board, you'll have to take that class again. Otherwise, it lasts for 7 years. That course, again, needs to be at least 4 hours long. Makes perfect sense to me that the legislature would decide the length of the course and not just the content, right? But it does need to be 4 hours long. And if you were elected or appointed before July 1st, 2024, you have until June 30th, 2025 to complete this if you have already done the certification under the old requirements. If you didn't get certified under the old requirements, technically you're already suspended from the board until you complete the new requirement, which again is the 4-hour class, getting a certificate from that class, and also signing the certificate saying I've done what I need to do. Developer appointed board members can be certified. That's valid for 7 years for condos, barring any interruption in service. And that doesn't matter how many different boards that person serves on. This certificate will be good for every one of those boards for a developer appointed director. The additional requirement is you have to take a class like this. Now, as Jeff mentioned, we're not sure whether DBPR is going to give board credit for this type of class because it does include HOA and condo, but condos need to take a 1 hour per year class on legal updates. Again, we don't know because DBPR has still not told us. We're usually one of the first, maybe 5 firms to find out what's going on and be approved to teach those types of courses. We are approved to teach this class, so don't freak out for manager credit, but I'm not aware of anyone that's been authorized in the state of Florida yet to teach these classes for board members. The problem I have with that is that you've got an obligation to complete at least that 1 hour if you're in a condo by June of next year. When are you supposed to get this done? Are they going to approve it in May? I just don't know what's going to happen there, and we can't really verify what the DBPR intends to do because we can only follow up and follow up and follow up and not get answers. Unfortunately, we can't create the answers for you guys.
Yeah, I
So,
have a feeling that my face is on a dartboard at the DBPR because I'm asking them every week about this. So I think, but I just want a quick interruption so you could have a quick drink of water there,
sure.
Alan. Is that I'm getting a few questions in the Q&A about these slides. If you came on a little bit late, yes, just hang on tight. Make sure the chat is enabled so you can see the chat area. It'll say disabled for you, but we can send stuff your way. And that is where we're going to place the link for the evaluation at the end. After filling out the evaluation, you'll have access to download and save today's slides. Back to you, sir.
All right, thank you. As I mentioned, once this certification is completed, you give it to your secretary, your manager. It stays in the official records of the association for 7 years, like I said, which is how long this is valid for, or the duration of the director's uninterrupted tenure, whichever is longer. I don't understand why you would keep it longer if it's no longer valid, but apparently that's what the legislature wants you to do. So you do it, is the answer. Failure to have that certification does not affect the validity of any board action taken. It just means that that director is technically suspended if it's been more than 90 days after they were elected or appointed. Moving on to the HOA board certification requirements and education requirements. Same requirement. The distinctions between what I mentioned for condos and what applies to HOAs is that the certificate is only valid for up to 4 years. The class does not need to be 4 hours long, so I teach it as roughly 2.5 hours plus a half-hour Q&A. So that's a total 3-hour class that we attribute to it. You do need to do this every 4 years. Again, the 90-day requirement, getting it into the official records, signing the certificate, all that still applies. The distinction is major when it comes to the ongoing education requirement. And again, DBPR has not quite told us yet who's able to do this, teach these classes, what they will be, and how. So just, if you are not already on our mailing list, my recommendation is to get onto it by filling out your survey at the end of this class. Jeff will talk about that later. But click the little button that says, I want to be added to your mailing list because Once we start teaching those classes, just like you might have gotten the email for this one, you'll get one for those classes as well, or you'll get one saying we're now authorized to teach this class for both kinds of credit.
Exactly. All the promotions will explicitly mention what it counts for once we have all the clarification.
Right. Thank you, Jeff. So understand the amount of education that you need is based on, for some reason, not the dollars that come into your community, but the physical size of your community. So if you have less than 2,500 lots in your community, and technically the statutory term is parcels, your board, each director needs to complete an additional 4 hours of continuing education each year. A director that in a community with 2,500 lots or more needs to do 8 hours. So that's basically one full day of education every year. I know that's a lot. It's a lot for us to teach as well. As soon as we're able to teach it, we'll decide whether we want to do kind of a boot camp that gets you through the entire educational content and requirement in one day. Or I know we will definitely split it up. The question is whether we'll be able and willing to shove it all into a single day so you can just get it done and go home and go to sleep, frankly, which is what I'll do after I teach for that full day. Same requirements. Now, the director needs to retain, or the association needs to retain, that certificate for 5 years in an HOA as compared to the 7 that's in a condo. Again, we've got distinctions. 7 years that this is good for in a condo, 4 in an HOA, 1 hour of continuing education in a condo, 4 to 8, depending on the size of your community in an HOA, retained for 7 years in a condo, 5 in an HOA, or as long as that person serves, whichever's longer. All right, moving on to some HOA specific changes. We already had a fiduciary duty that was applicable to the directors and officers of the association. What this means is that the association, the directors and officers, have a duty that is the highest duty imposed by law. Essentially, a fiduciary duty means you have to do what's in the best interest of the corporation, even if it's going to hurt you personally. Okay, you can't take advantage of that fiduciary relationship where there's trust that you're going to do the right thing as a director. So you need to do the statutory definition was just made a little bit clearer as of April 5th of this year. The bottom line is you are protected to a large extent by what's called the business judgment rule. I call it the dumbest guy in the room standard. That's not entirely accurate. What it really is that you have to do what you reasonably believe to be in the best interest of the corporation, even if it hurts you, even if it benefits you. There's nothing that says that a director can't benefit the same way that everyone else in the community benefits from a board decision. All right. You can, and this is a way of protecting yourself from personal liability when someone files a breach of fiduciary duty claim. Now, I usually joke, and I'll make kind of a joke, but it's really not a joke, that your third most important bill that you'll pay every single year is the one that you pay to your directors and officers liability insurance carrier. That's the policy that's going to protect the individual directors and the individual officers if they are sued personally instead of the association being sued for something that they did in the context of their service to the association. Now, I say that's the third most important. I jokingly say that we're the first, management's the second. In reality, it's mostly management's the first, we're second, directors and officers is third. But moving forward, so you can rely on professionals' opinions, reports, or statements, including financials, if it's prepared by someone who is basically qualified to provide the opinion, and that is a business basis to have relied on that opinion, you are technically protected even further than the business judgment rule from the decisions that you made, even if they're completely wrong. Okay, you can basically say, well, I relied on advice of counsel in telling that person they couldn't do what they were supposed to do. It's not that I told them that they couldn't do it because I think they're a jerk. Okay, so a lot of times when people say we don't want to spend the money to get a legal opinion or to get an engineering report or an architect's report, etc., you're doing that not only to protect the association from potential liability, but now you're also doing it as a matter of statute in an HOA to protect yourself as a director and officer. Now, if you do not follow advice of counsel, you are not considered acting in good faith. And I say counsel, what I really mean is these professionals. So what that means is if I write a legal opinion and I say, I think you're doing this wrong if you do it this way, I really recommend against it. And I don't say it's your prerogative to do what you want. And I say this is blatantly against the statute or against your governing documents, and you choose to do it anyway, that protection from the business judgment rule, that protection from personal liability will disappear under Florida law. So just understand if you are relying on experts, you're doing the right thing, whether you get it right or not, is the way that the law looks at it. Financial reporting for HOAs. This is the Mo Money, Mo Problems paradigm is what I call it. The more money that you have in annual revenues, the higher reporting level for your finances is required. The distinction this year is that it used to be just based on the dollars. There was another one added, which is item D in this slide, which says that an association with at least 1,000 parcels needs to prepare an audit regardless of what dollars you bring in. So even if you're charging $1 per lot per year and you're only bringing in $1,000 a year, you still need to do an audit if you've got 1,000 or more lots. So just understand it's not just the dollars anymore in an HOA. Condo has not changed in that respect. So if you want to reduce your reporting requirements, you must have an audit regardless of the amount of total annual revenues in an HOA with 1,000 or more lots, and you can't prepare a lesser financial statement for 2 or more years in a row. What that means is if you take that member vote to reduce the financial reporting requirement, and let's go, well, that's right here. If you had to get an audit, for example, and you wanted to take a step back and have a reviewed statement, okay, you can do that, but only for 1 year with a member vote. It used to be you could do it almost as long as you wanted. You could have it for consecutive years. Now you cannot do that in an HOA, period. All right, debit cards. This has been a condo issue for a while. It is now also an issue that needs to be addressed in HOA land. So I think it was 2018 when the condo statute was changed to say you really can't use a debit card in the name of the association. If you do it improperly, it's a misdemeanor. So I'm going to tell you the workaround here, or 2 workarounds, and then I'll go through what the law is. Stop using debit cards in the name of the association. Use your own and get reimbursed by the association, or use a credit card in the name of the association or your own. So what the law now says is that if you use a debit card that's in the name of the association or billed directly to the association for paying association expenses, and that expense is not a lawful obligation of the association, which means that it was approved in advance in writing, then you have technically committed a misdemeanor now. It's theft. Okay. Well, I say it's a misdemeanor. In reality, it's theft in whatever dollar figure you're dealing with, which will determine the level of criminal penalties that are appropriate or allowed. So a lawful obligation of the association requires that you get the approval in advance in a board meeting and that the minutes are actually entered, or it's a one-time expense that's directly in the budget. So bottom line, this is becoming a huge pain in the behind to try and use this type of debit card. So just stop doing it. You won't have to worry about this statute. You won't be risking criminal penalties if you just use another payment method, even if you pay the exact same amount in the exact same manner, just with a different card. So my suggestion, use a different card. All right. You do need to provide financial accounting for an owner's individual account within 15 business days after you receive the written request. They can't make that written request. And by the way, this is another burden on the association that didn't exist before. It used to just be, well, here's what's in the association records. Now you're kind of creating an accounting for them. Now, hopefully you're maintaining that accounting all along, but if you're not, you now have to. That person can't make another request for that accounting for at least another 90 calendar days. Here's the downside. If you do not respond within those 15 business days, any outstanding fines that the owner owed are gone. They're written off. And we'll get into it in a minute, but in Chapter 720, the HOA Act, which is what we're talking about right now, It's become extremely cumbersome to even levy fines in the first place. So now the legislature is saying, we don't want you levying them, but if you do and someone asks you for a breakdown of the fines and you don't provide that within 15 business days, they don't know the fines anyway. Now, what I want you to understand, because I've had it come up already where people are saying they didn't provide this breakdown, I don't owe any assessments. I don't owe any rekeying charges. I don't owe anything for my key fob that you gave me. Wrong. Incorrect. In the words of the immortal Dwight Schrute, false. Okay, this is not correct. The only thing that would be written off if this record is not provided within 15 business days is going to be a fine. Now, hopefully you've been listening to me for the last 2.5 years, possibly longer if you were listening to me with a previous firm that will remain nameless. But I don't like fines. I think they're a waste of your time because they don't accomplish anything other than saying someone owes you money. So if you're not fining, you don't have to produce this and risk that those fines will be wiped out anyway. You still have to produce it with respect to other charges, but you're not dealing with this issue at all in an HOA if you're not fining. And by the way, check out our covenant enforcement class if you want more information on that. We just don't have time to get into it today. Kickbacks are another thing. In condo land, these were illegal, and there was a statute that was put into place in 2018. This is now transferring over to HOA land. So you're seeing a lot of conversion where there was a big disparity between the condo statute and the HOA statute. The legislature seems to be pushing to make them all the same. That would make my life a lot easier because I would only have to know one set of statutes, but it's also very inconvenient for an HOA that's been operating the same way for 60 years to be told, well, now you need to comply with statutes that have never applied to you before. But bottom line, we are sitting here with a criminal penalty. It's a felony of the third degree to accept a kickback. The director is also booted off the board immediately. The vacancy is filled until the end of the term of office. You can accept food to be consumed at a business meeting with a value of less than $25 per individual, or services or goods received in connection with trade fairs or education programs. Understand that the bottom line, you can accept certain things. You can't accept someone saying, I'll paint your house first if you work with our painting company. You can't have someone say, I'll paint the inside of your house if you contract with with our company to paint the exterior of your condo or HOA building. That's a kickback. That's a no-no. Okay. Again, felony of the third degree. Don't accept those things. If you are being taken out to grab a meal, make sure it's at the ale house, not at Ruth's Chris or Christner's, or some other fancy steakhouse. You can accept those little stress balls that I'd like to throw at Jeff at all of our events that he attends. You can accept pens. Yep, there you go. You can accept the pads that are branded. You can accept swag, but I would not accept a TV from someone who's trying to contract with the association. Now, again, you get removed from office. There are other things that are now considered illegal acts and criminal penalties apply. Forgery of ballot envelopes, theft or embezzlement involving association funds or property, destruction of records or failing and refusing to allow inspection of records, obstruction of justice, or any criminal violation under Chapter 720 is something that will get you booted off the board. Now, I want you to understand, this is not John down the road who's on the board accused me of doing something wrong and now I'm off the board. Now, look at what it says in this first bullet point of this whole slide. Charged by information or indictment. Okay, what does that mean? There's a prosecutor that looked at this situation and is willing to put their neck on the line by saying, yeah, I think this is bad enough that we should pursue it in court. That's the type of charge that you need to have in order for this to move forward. Okay, we had architectural control covenants where you were limited in how you could enforce. If it wasn't visible from the frontage of the lot or from an adjacent lot, the legislature said you weren't allowed to enforce. I won't get into whether that's allowed under Florida law, meaning whether that's constitutional and whether your specific community can tell the legislature, sorry, you did it wrong. That doesn't apply to me. Run that by your attorney if you're not sure. But before you stop enforcing these covenants, is what I'm saying, run that by your attorney. Now, the difference between last year and this year is that those architectural covenants, or the changes that are being made to a lot, basically something being installed, maintained, or stored on a lot, or displayed on a lot, you now have control if it's visible. Even under the statute, you have control, so the statute doesn't apply. If it's visible from an adjacent lot, the frontage, these were the ones that were there last year. And this year they added if it's visible from an adjacent common area or an adjacent golf course. What they still didn't involve is an adjacent lake. So if you're across the lake from a lot and it's visible across the lake, that lake is still the adjacent thing, not the adjacent lot. But again, covenant enforcement class is a good one to check out. The main difference, because we are starting to run low on time, is that the association is limited based on the visibility, or at least that's what the statute says. Okay, there's also a law that went into place in HOA land that says if you can't see this from outside because it's not actually outside of the item, outside of the residence, okay, that's also something the association won't be able to enforce. Again, constitutionality comes into play here. You're going to want to run this by your attorney before you decide we're not going to enforce our covenants anymore. Don't just take the legislature's word for it, because in most HOAs, in my opinion, they got this one wrong by not making it so that it only applies if you've adopted future changes to the statutes. Long story. I won't get into it right now about how that works because we don't have time. But the bottom line is make sure that you're running these things by your attorney before you just say, we're not going to do this anymore. And if your attorney automatically, without looking at your documents, says, well, that's what the statute says, so you have to apply it, you might want to consider another attorney to deal with this type of issue, or to deal with your entire community, because it seems like they're missing a major issue here. Now, I mentioned the plans and specifications for internal things. What we're talking about here is in item 2 here, the central AC, refrigeration, heating, ventilation, construction improvement that's internal to the structure of your HOA residence. Basically, if it's not visible from any of these areas that I mentioned earlier, and it's substantially similar to a system that's approved or recommended by the association or a committee, it's going to have to be allowed under this new statute. Again, whether that statute applies to your community is the issue that I can't tell you without, pardon me, looking at your governing documents. If you're going to deny an architectural request, someone wants to install something on their lot, they want to add a shed. Forget about whether sheds are required or not for purposes of this discussion. If you're going to deny the request, you now have to provide a reason for that denial. You need to point to a specific provision within your governing documents. That could be your architectural criteria, whatever that may be. But you need to point in your denial letter to the specific reason and the specific provision that says that they can't have what they're asking to put on their lot. Now, what does this mean for you? It means that you probably need to have architectural criteria if you don't already, so that you have specific criteria to point to, because the old, well, it's not aesthetically pleasing, generally is not going to be sufficient under the law that changed a couple years ago, and it's definitely not going to be sufficient for most purposes under this law. Now, there are changes that you can make. You can adopt architectural criteria that kind of protect by putting in the standard that's in the community now versus putting in nothing. But keep in mind, if you don't have any architectural standards, you probably don't have the right to deny anything unless you have really clear restrictions in your declaration. Another amendment that we've been working on over the last few months is one that basically authorizes the board to adopt specifications for everything that you might want to put in. Materials, colors, whatever, for roofs, for the residence itself, for sheds, for everything. And that's just a lump sum amendment so that you actually have authorization that's required in your declaration to actually even adopt those architectural standards. So that's something to consider if you don't have that in your declaration already. We talked about installation and delay of items. You can't restrict tenants from installing, displaying, or storing anything that isn't visible from these areas. That includes artificial turf, boats, flags, vegetable gardens, clotheslines, and RVs. Now, We mention all these things. What you don't hear in the statute is if the installation of this item, for example, let's say it's artificial turf, and the drainage on this lot goes to crap. All of a sudden, there's really no drainage. Okay. At that point where there is no drainage, now all of a sudden you're in a situation where you've got a violation that's separate and apart from the initial installation that wasn't approved. That secondary violation is still enforceable even under the statute. That drainage that, all of a sudden you're flooding the neighboring lot, or you're flooding a common area, you're flooding the street, whatever it may be. Okay. That secondary violation is still enforceable. We'll get into something similar when we talk about the trucks and commercial vehicles. Okay, fining and suspension, regardless of what's in the governing documents, you can't levy a fine. Again, I think that's a waste of time, but go for it. Or impose a suspension of use rights or voting rights for any of the following: leaving garbage cans at the curb or end of the driveway within 24 hours before or after the designated garbage collection day or time. So according to the legislature, you can leave your garbage out for at least 2 days if you've got separate garbage or separate recycling days. It could be that you can just leave those things out all week, according to the legislature. Not a big fan of this, and I'd love to see someone actually challenge it, but it is what it is as of now, as much as I hate that phrase. Holiday decor, leaving that out longer than indicated in the governing documents is generally going to be okay unless the decorations are left up for at least a week longer after the association says you need to take them down. So basically, until the association says you need to take them down and sends a demand, you pretty much don't, according to the statute. You can leave them up as long as you want. Again, whether this applies or if it so substantively changes the way that the community is supposed to operate that it doesn't apply is something you'll want to run by your attorney. So don't presume that these statutes apply. They make major changes to your operation. And in my opinion, some of them are so substantial and substantive that they just shouldn't apply to a community association that doesn't try through the language in the declaration to adopt all changes to the statute. Again, sorry if that's a little bit more complicated than you want it to be. Again, run it by your attorney. Okay, I mentioned the pickup trucks, the work vehicles. There is also a prohibition for HOAs this year where you are not allowed to tell someone that they can't have a pickup truck or a work vehicle, basically a commercial vehicle, in their driveway or any other place that vehicles are permitted to park within the community. Now, this doesn't mean they can park wherever they want, even if it's that type of vehicle or not. That is not what the statute says. It says where vehicles are permitted to park, these vehicles are permitted to park, even if your governing documents say otherwise. Again, this is one of those, I think it's unconstitutional unless your governing documents have specific language. Take it up with your attorney, verify whether this is something you can still enforce if it's in your governing documents. The work vehicles, keep in mind there is an exception. Now, if it's a business vehicle that has commercial signage, that's one thing. But you are still allowed to enforce if it's a commercial motor vehicle as defined in the statute. Now, that's really like a semi. It's got to be 26,000 pounds and a minimum of 3 axles. So very few of those being parked in an HOA. But if that's something you're seeing, that's still not allowed. Now, I talked about secondary violations before. What you still can do, presuming you've got the authority to do it otherwise under your governing documents and you're not dealing with municipal roads, you still can enforce, even against these trucks and work vehicles, a restriction that says you can't park in certain areas or that you can't block visibility around the corner because some of these vehicles are larger, or that you can't block access through the roads because some of these vehicles are wider. So keep in mind, the secondary violations are still enforceable, even if you choose to apply the statute or it actually applies to your community. Contractors, I don't understand this one at all, but the governing documents can't permit a contractor from working in the community just because they're not on a preferred vendor list. Okay, fine with me, but also can't preclude them because they're not licensed or insured. So apparently the legislature doesn't think that protecting your neighbors and protecting the common areas of the community is important anymore. I don't understand this one at all, but it is the law as of now. Again, I would run it by your attorney to see whether this applies to your community. You also need to let certain vehicles in. We talked about this one. I thought it was the other one. Okay, well, we'll get to that later, but basically you need to let emergency responder vehicles park in an HOA, even if they would otherwise qualify for a commercial vehicle restriction. I hate to tell you, but if you're sitting there and telling someone you can't park your take-home vehicle as a police officer, fireman, EMS, whatever it may be, don't bring that violation to me, please. I'm I am heavily into covenant enforcement. Literally wrote the book for HOAs that's being published by the Florida Bar. Wrote the book for defenses for condos. I am not enforcing that one. So moving along. Grievance hearing timing. It used to be that people would argue that you only needed to provide the opportunity for a hearing before a grievance committee if you're trying to fine or suspend use or voting rights in an HOA. It has become very clear that needs to be actually held now, not just offered to have that grievance committee hearing 14 days after written notice. It is also clarified that the hearings can be held electronically, either by video or by phone, which is kind of nice. Good job, legislature. You also need to provide notice after the hearing. Within 7 days after the hearing, you need to tell the owner what the result of that hearing was. Usually that's going to go out the day after. It's also going to have to contain the reasons that the board or the committee made its decision, the date when the owner needs to cure the violation or pay the fine or whatever it may be, etc. Now, I mentioned that there are different requirements for fining now. One of them is the owner basically has until the minute before the fining committee hearing starts to cure the violation. If that violation is cured before the meeting, which by the way, you already need to have a board meeting, which means 48 hours notice. Then you need to send a 14-day notice. So we're now up to somewhere between 16 and 20 days minimum. And that usually is following notices by the manager or the board that are up to 45 days, and then it's fining. So you're sitting here telling someone, well, we've been telling you for 2 months or more that you need to cure this, but if you cure it the day of the hearing, no harm, no foul. We went through all this rigmarole. We wasted all our time to get you, pardon me, into compliance. And now you've avoided responsibility for all of the expenses because you cured it the day of. That's one reason I suggest considering an amendment to your declaration so that any fees, costs, or other expenses incurred in enforcement are an assessment against that individual lot or unit, regardless of whether a lawsuit's filed. That way, the person that caused the problem and caused the expenses is inevitably going to be responsible for paying them, not just treating it as a cost of doing business to have an attorney send a notice out or have management send notices out. Now, here's another one. The payment date for the fine needs to be at least 30 days after the written notice is delivered following the hearing results. So now you've given them the 60 days, whatever you're giving them, minimum of 20-ish days. Now they have another 30 to pay this off. And if you are fining, no attorney's fees or costs can be awarded against the owner based on actions taken by the board before the date set for the fine to be paid. So you basically have a 30-day holding pattern for no reason. And what are you going to do with the fines? Are you going to file a lawsuit to collect them? I've seen one community in my entire career actually do that. Failure to cure the violation. If the fine is approved, the owner has to pay the fines, and attorney's fees can't approve until the time for an appeal of that fine has expired if there is an appeal period under your governing documents. We talked about fraudulent voting activities before. This is a little bit clearer. There are penalties. If you engage in fraudulent voting activities, it is a misdemeanor of the first degree. This is willfully or falsely swearing to or affirming or willfully procuring another person to falsely swear or affirm an oath in connection with voting activities, meaning, oh, yeah, sure, I will attest that I sent out that meeting notice, something like that. Perpetrating or attempting to perpetrate or aiding in perpetration of fraud in connection with votes, preventing a member from voting, changing their vote or attempting to change their vote, changing the voting certificate so that someone else is authorized to vote on behalf of that unit or lot. And here it's a lot. Threatening anyone or bribing them or otherwise using corruption to attempt to influence someone in voting, giving, promising, basically giving a kickback. This in connection with a vote that does not apply to food served at an election rally or meeting of nominal value. Again, we're not talking about bringing everyone to Ruth's Chris and saying, if you vote for me, you can come to this dinner. It also doesn't include a campaign message designed to be worn by a member. So that's a t-shirt or a pin or a button, something like that. And then we talk about use of violence and things of that nature. Fraudulent voting activities. There are new criminal penalties, misdemeanor of the first degree, if you do any of these things. I'm not going to go through them in detail. Understand that a licensed attorney can give legal advice to a client. That is not going to have the attorney responsible, but a director, officer, manager, or anyone else who is involved in this situation might be liable for criminal penalties for doing any of these things. So bottom line, let the election be how it's going to be. I hate to be blunt as someone who practices this area of law day in, day out. There's nothing that's going to be decided at that election that is important enough to let you go to jail over it. Okay, so we clarified in the statute, it was always clear to me, but there is no compound interest on unpaid assessments. The rate is 18% per year of simple interest, meaning it does not compound interest on interest. It's not interest on late fees. It's not interest on attorney's fees. It's interest on assessments. We won't get into how to calculate what's an assessment versus the others, but bottom line, you're not accruing interest on interest in this context of collecting unpaid assessments. Electronic voting, the good news for this one, if you're already using it or you've been considering it, you can now opt into electronic voting electronically in and of itself. So rather than having to sign a document and get it over to the association, you can now either DocuSign or you can fill out a form online that the association sets up, or hopefully that your vendor sets up for you. I talked about the first responder vehicles. We can skip that one. Okay, hopefully you've already done this if you're in an HOA, but by October 1st of this year, the association was required to provide copies or something saying that a copy is available to every member of the association of all of your governing documents and your rules and regulations, your architectural criteria, your policies, whatever is going to govern the operation of your association was supposed to be provided. Now, communities that are working with our firm, we will literally, or at least with my office, the first thing I do for every new client, everyone within the firm will order the governing documents. I go a step further to make this particular process easier, although this wasn't initially the purpose, and I will compile the governing documents in a one PDF, bookmark it, OCR it, and get it back to the association. So what that does for the association is the board has one set of documents to operate from, the manager has one set of documents to operate from, the lawyer does. But if you choose to share that with your members, the members also have access to a bookmarked OCR copy so that they have zero basis whatsoever to argue that they don't know what the documents require of them. I do have communities that choose to work with us just to get this project done, and then they'll reach out maybe 6 months later when they need something else done. Okay, since everyone should have complied with this already, I won't go through the details. Another HOA bill, regardless of date created, the board or similar committee, you need to adopt hurricane protection specifications. This might already be in your declaration. It might be in your architectural criteria. If it's not, you are too late and you're already out of sync with what the statutes require. So this is policy number 3 that I'll mention for today that I think every community and association in Florida should have, and so does the legislature as well. Let's see. So I'm going to skip this. Condos, welcome back. We have the structural integrity reserve studies and milestone inspections. Understand the milestone inspection requirement doesn't apply to a single family, 2-family, 3-family, and this year we added 4-family dwelling with 3 or fewer habitable stories above ground. So generally it's going to apply to 3-story condo units or co-op units. And when I say units, what I actually meant was buildings. Here we're clarifying, even if it's 3 stories, if you have 4 or fewer dwellings within the entire building, this requirement won't apply. So this is for the quadruplex, I guess I would call it. Certain definitions were changed. They don't really change the substance, in my opinion, from a perspective of a board member or manager. They're really legal changes. If there's a condominium that's created within a building, that is now permitted by statute, although it was always permitted by law. What we're talking about here is largely the downstairs is a bunch of retail, the upstairs is condo units, or you've got your condo hotel set up, things of that nature. The legislature is expressly authorizing that creation now, whereas before it was just something that was done. Condo electronic voting, if the association opts in to electronic voting and a member opts in to electronic voting, the board needs to honor that unit owner's request to vote electronically indefinitely, even if the board is not using electronic voting at that particular vote. So I think this is a little bit ridiculous, but any owner who opts into electronic voting is going to be allowed to vote electronically at every meeting from there on. Now, what that doesn't say is that you need to send over the opportunity and say, oh, well, we're not using electronic voting, but if anyone wants to do it, we have to allow it. That owner needs to reach out and say, hey, I want to vote electronically, and then you set it up. So this is not you need to incur that cost every time, but it is if the owner requests it, you need to incur that cost and do it that way. An owner, again, can consent to using online voting by email. So this is a separate, not just signing up on a form. Understand this is by email. Okay, kickbacks. Nothing was really changed except the penalty is now, it's a penalty. Kickbacks are now a felony of the third degree, punishable by up to 5 years in prison, along with up to $5,000 in monetary penalties. So I promise you that TV is not worth $5,000 and 5 years in prison. It's not, period. And frankly, anyone that would consider accepting a kickback shouldn't be on the board in the first place, in my opinion. If the DBPR gets a complaint that the association isn't maintaining proper insurance or fidelity bonding. Now, when we say proper insurance, there's really no statutory definition there. It's just, are you maintaining the insurance that's needed to cover what you might need? That's something you'll want to take up with your insurance agent, and probably not your attorney. Or fidelity bonding, which is people that are going to be spending association funds or having access to association funds, making sure that the association's protected from theft, basically. If that complaint comes in, doesn't matter who it's coming to or who it's coming from, the division must monitor the association for compliance and can issue fines and penalties. So note that I said must. The DBPR, the government, is going to be monitoring your operation with respect to these issues if anyone complains. That can be a huge pain. So bottom line, do what you're supposed to do. I know that sounds crazy. Still in condos, while the membership can vote to obtain a lesser financial report than otherwise required, again, you can't do this in consecutive fiscal years. Pardon me. So that's the same thing I said for HOAs earlier. It applies to condos now as well. While the law does provide that the association can't use debit cards issued in the name of the association or billed directly, anyone that uses that for an expense that's not a lawful obligation of the association is also committing theft and punishable under the criminal statutes, again, based on the amount of money spent. So again, it's not just, well, it's a misdemeanor. No. Look at what you're spending on that debit card. That's the basis for what the criminal penalty will be. And it could be grand theft depending on how much you're spending, even if it is an appropriate association expense because you did it wrong. 718, which is condos again, a residential condo with more than 10 units needs to meet at least once a year now. I'm sorry, at least once a quarter. So really, you used to have just, well, we'll have a board meeting when something comes up, and if nothing came up, you didn't have one. Hopefully, you're having one maybe once a month, once a quarter. This is saying you must meet at least once a quarter. Now, keep in mind, this next sentence is separate and apart from that requirement. At least 4 times a year, the agenda itself must include an opportunity for members to ask questions of the board. The members also have a right to ask questions on every designated agenda item during the time that they're permitted to speak. One of the reasons I recommend, number 4, member participation at meetings policy, governing how they're able to ask those questions, when they're able to ask them, how long they're supposed to speak, because you can limit that to 3 minutes per agenda item. Now, I mentioned that the members have the ability to ask those questions of the board. Nothing in the statute says you need to actually answer the question or even promise to answer the question. You're just required to allow those members to ask the questions. If you are considering a contract for goods or services, a copy of the contract must be provided with the meeting notice made available for inspection and copying, or made available on the website. So if you're considering that contract with a new attorney, because you like this presentation, bottom line, that contract, the proposal package, needs to be made available to the members before you vote, before you meet to vote. Structural integrity reserve studies. Co-ops, congratulations. We're finally getting to one that applies to you guys. But this is condo and co-op. Within 45 days after receiving a CEUs, the report itself, the association needs to provide a copy to each owner and or a notice. I'm sorry, because this is a super lengthy document. The alternative is you provide a notice that the completed study is available for inspection and copying, and provide the division, this is a government entity, with a statement indicating the study was completed and the association provided it to the members, or let the members know that it is available. Now, I'm being told that that division website where you're supposed to fill that information out and confirm with them that you've done what you're supposed to do is also asking for you to submit a copy. I don't know of anything in Florida law that requires you to do that. So my perspective is, unless your attorney says otherwise, it's voluntary to actually attach a copy. Now, keep in mind, directors and officers are generally going to be guilty until proven innocent once they are charged. This is not if they are told, or your board is told by some angry member that they did these things. Okay, it's actually charged with a crime, but it's forgery of ballot envelopes or voting certificates, theft or embezzlement of funds, destruction of records, failure to allow inspection, blah, blah, blah. Now, keep in mind, when those charges are pending, the director or officer can't be appointed or elected as a director or officer to any association in Florida, and can't have access to official records of the association except pursuant to court order. This is condo specific. I don't know why it doesn't also apply to HOAs, because this one actually makes sense. You wouldn't want someone who has pending criminal charges pertaining to another HOA on your condo board, or vice versa. But as of now, the legislature's done what it's done, and maybe we'll get a fix next year. We talked about fraudulent voting activity, pretty much the same in condos as it is in HOAs. Difference being, this is a misdemeanor of the first degree, which means up to 1 year in jail. And hurricane protection. So there are certain definitions. We talked about the hurricane protection specs that's required in a condo, just like an HOA now. And the installation, maintenance, repair, replacement, and operation of hurricane protection is not a material alteration or substantial addition to the common elements. What does this mean? If your documents require, or you are relying on the statute that requires a material alteration vote of the members to protect your building, you don't need that vote. Now, there's case law that said you wouldn't need it anyway, in my opinion, but I don't have a problem with the legislature clarifying a little bit further. Okay, we got a little bit of time. I'm going to kind of speed through some of this. As to the expense, you'll want to read through this slide as to who's responsible for the expense of installation, removal, or if the association is doing other maintenance to take it off and put it back on. Who's responsible for that is stated kind of clearly in these slides. Let's see, I think most of this is going to be in your policy, so we can skip a lot of it, but I would read through. I do want to try and make sure we get to the Q&A, so I'm going to skip through some of this material. The statute of repose is another one that was drastically changed. So we're talking about when you are allowed to even file a lawsuit for a construction defect claim. There's the statute of limitations, which is a defense that you can raise. But then there's the statute of repose, which says you can't even file the lawsuit. It'll be kicked out of court pretty much right away if the other side challenges you. So that statute of repose has changed over the last couple of years. It was clarified. Last year it was clarified that it is now 7 years It used to be from the date a certificate of occupancy was issued, but that didn't mean that the association had turned over or that the members had the ability to do the engineering studies that are required to determine whether there is or is not a construction defect in the construction of the building. So the legislature listened to us on this one and basically said, you know what? We're going to change this up a little bit. It's still 7 years, which is less than it's been in past years, but that 7 years doesn't kick in until turnover happens. So when the members gain control of the community, that's when this 7 years starts. So my suggestion is get those engineers out there right away, and you'll have plenty of time to work with the developer to fix these problems rather than have to rush into a lawsuit or avoid the ability to file that lawsuit altogether. SLAPP suits were also addressed in the legislation. This is basically a lawsuit that is in retaliation for an owner filing a complaint or raising a complaint. There are SLAPP suit prohibitions. You can't file an action against a member in retaliation. The association is also now unable to bring a defamation claim on behalf of any of its directors. That, I think, is the biggest one here, that you can't bring a retaliation claim, you can't bring a defamation claim because a member of the community is bad mouthing one of the directors. Like, that would be an individual. You can still bring the claim, but it's the individual with the claim that has to bring it, not the board or the association on behalf of the individual or individuals. Okay. Let's see. Developer turnover inspection reports, the CEUs that the developer performed now also needs to be included in that developer turnover inspection report. A director with a conflict can establish a quorum at a board meeting in a condo just to allow a vote to proceed in their absence from the vote due to the conflict, meaning they can show up, they can establish the quorum of directors so that the 2/3 of the remaining directors can vote. They'll count towards the quorum. They still don't get to vote on that conflicted issue. Suspension of voting rights at least 90 days before an election. Written notice needs to be provided to the unit owner that their voting rights might be suspended due to non-payment. Before, it was just you have the vote, even if that vote is taken, a week before the election, and they don't receive the actual notice that their right was suspended until after the election, because USPS takes 5 to 7 days to get everything delivered now. That went away. In a condo, at least. In an HOA, you can still do exactly what I just described. In a condo, you need to provide at least 90 days of the intent to suspend those voting rights before the election. Jurisdiction of the division was expanded. I won't go through the specifics. You're welcome to read through that. They can refer things to law enforcement, meaning some of the crimes that we mentioned throughout the presentation today can be referred directly to law enforcement by the DBPR. They have the right to attend meetings if they're in the middle of an investigation. So this may be a government entity actually attending your board or member meetings. That's not fun. Let's see. A condo or a co-op that operates a timeshare plan can now delete facilities with a 2/3 vote of the board. These are all timeshare things. I don't know that there's anyone here that's going to really need to hear this, but please read through it if you are in a timeshare, condo, or co-op. These are mobile home park changes, so I won't really go through those. Educational initiatives are just something that we were told we need to put in here, so we did. Out-of-state CAMs, the licensure requirements, including licensure by Florida, and there's some reciprocity with out-of-state community association managers. Don't know why that needs to be in here, because they don't require us to actually tell you what it says, and frankly, I don't even bother reading this particular bill. The Corporate Transparency Act affects all board members. Now, the good news is, as of this recording on December 18th, 2024, the Corporate Transparency Act has been suspended and all registration is voluntary as of now. There's an order in place that blocked the Corporate Transparency Act, and FinCEN, which is the government entity that's doing all of the things under the Corporate Transparency Act, has voluntarily said, based on that order, registration for beneficial ownership information is voluntary. Now let's take a step back and tell you what this is. The Corporate Transparency Act was a federal act, or is a federal act, that essentially is intended to protect against counterterrorism and money laundering with the use of a business as the front, so to speak. It applies to every corporation in the entire US. So this is not a Florida specific thing. It's not a community association specific thing. And as a result of that, it's a little bit more expansive than it should be, in my opinion. Community associations, you may have directors that are doing things wrong and bad, but I've never known that a community association, the corporation, the not-for-profit corporation that runs it, is actually part of a money laundering scheme or part of a terrorist operation. That's the purpose of the statute. So it shouldn't really be applied to community association corporations anyway, but technically it does. And what it requires is that all of the board members, the people that have a beneficial ownership interest, or more accurately stated, that's the legal term, I will call it a controlling interest in what the corporation does, are required to file. Now, I don't think that the members need to file. I don't think the officers need to file unless their obligations are to make decisions on behalf of the association. I don't think the manager needs to file unless they are making decisions on behalf of the association. But clearly, the board members would be obligated if you are going to comply with this statute, if it's required. Now, it used to be, or the statute actually says that there's an obligation to complete that requirement for all Florida community associations and other corporations by December 31st, 2024. Then we have an order that extends that out and says that communities in certain counties in Florida were hit by 2 hurricanes in the last year. Their deadline's extended to June 30th, 2025. We've put out a bulletin through Rembaum's Roundup that outlines which specific counties those are. But now we've got a court order out of, I believe it's the Eastern District of Texas, that explicitly says no one needs to comply with this, and anyone that chooses to is doing so voluntarily. So what it requires is that you actually file the name, address, and some identifying information. Usually that's going to be your social security number, your driver's license number, something similar, for every director or everyone with a beneficial ownership interest. Again, a beneficial owner is supposed to be doing this, but as of now, no one needs to do it. So if you've already done it, you've already complied, great. If you haven't, follow along on our mailing list, because we will send out an update if this becomes mandatory again. Right now, it's voluntary. We mention it because it was mandatory when this presentation was created. Up until about a week ago, it was mandatory. We're hoping that before it becomes mandatory again, community associations are exempted from this requirement, or it's just completely shut down and it ends permanently based on this ruling out of Texas. But as of right now, it's a temporary halt on filing requirements. And that is all we've got, folks. So I will close out and leave it to Jeff to do his thing.
Thank you. Well done. Excuse me. I had a couple of folks mention in there that we should split this class up into condo and HOA, and I think that person was confusing this with the certification classes. Those courses are split up. This is the legal update class. It has always been this way. So just in case anybody was a bit perplexed as to why it was taking place the way it did, that's because this is not the certification class.
Roughly 20 minutes. So let's see how many we can get through. There are some that I hate to say I'm going to skip, primarily because we're limited on time and they're not related to anything that we talked about today that would be appropriate for a board cert, but we're talking about specific changes to the statute. So I'm going to go through those specific changes, and if we have time, I'll get back to the other questions. But we have over 180 people on right now, so a lot of people asked. I think we've got 30 questions as of right now. All right. Can you confirm if the deadline for compliance with the record keeping on the website is 2025 or 2026? So let's go through that one very quickly. If you are on the association website requirements, it depends whether you're in an HOA or a condo. For an HOA, you have to do all this by January 1st, 2025, if you have 100 or more lots in your community. If you have less than that, you don't have a requirement under the statute at all to have a website. If you're in a condo and you have 150 units or more, you're already required to be doing this a couple years ago. If you are 25 to 149 units, then you've got until January 1st of 2026 to start complying. So I hope that answers your question, Bradley.
And it's a good idea whether you're required or not, because like Alan mentioned, that's going to save you and your team a lot of time if you can direct
Yeah,
people to the website, even if it's not a requirement.
correct. And Paul asks, can an HOA use the management company website instead of having their own? Absolutely. Just make sure that management usually will add a little bit something to the portal that they already had in order to ensure that they're complying with all of the requirements, because the portal in and of itself is usually not going to be sufficient. But most management companies that we work with are able to accommodate by just adding a page to that portal that will serve all the purposes needed. Raymond asks, should a monthly bank statement be posted on the website? Maybe, maybe not. Depends on the content of the bank statement. If it's an association bank statement, you might need to get it redacted for private bank account information of individuals before you post that to the website. But generally speaking, that is an association official record that at some point might make its way onto the website. Nancy asks, are legal records, that is conversation and advice from an attorney, required to be shared if requested or in an effort to be transparent after the lawsuit is completed, ended, finalized? So that is, you will get different answers from different attorneys. My personal legal opinion is that it is absolutely absurd to suggest that the private thoughts of the attorney that were shared with the board, that is confidential and privileged, should be open to everyone, and that the strategy of the association in their lawsuit or in their dispute should be shared when that lawsuit can be reopened at any time. I've seen cases that were over for 5 years that someone tried to reopen, and now all of a sudden they've got all of the private strategies that the association used. The other thing is, who knows whether that same strategy might be used in another lawsuit by the association. Now you've got no privilege regarding that strategy. So my perspective is it shouldn't be shared, but there are people that will absolutely tell you that the statute says that it should be shared, and that privilege only applies to pending and potential litigation.
Hmm.
My perspective is kind of there's always potential litigation, but that's not what I'm relying on here. It's just that I don't think it makes sense to make something no longer privileged unless the board decides that it's no longer privileged. Bernard asked, does a meeting where adoption of the operating budget and a new maintenance fee will be approved, does this require special notice requirements? Any meeting where you're adopting assessments requires a 14-day notice. That's the only special requirement. How can a board member serve the community? Paul asks, have some over 10 years. In an HOA, there's no time limit unless there's one in your bylaws. In a condo, there is an 8-year limitation, but that doesn't kick in until 2026 because the statute was changed in 2018. So as of now, there is no term limit in either act unless it is specifically stated in the bylaws.
Hmm.
Okay, we already answered Bill Hurlbert regarding the portal. Good to see you again, Bill. Chris asks, is if a condo board member is on their 8th year and no one else is running, can that board member run for the 9th consecutive year? Yes, they can. Keep in mind, again, that condo restriction for an 8-year term limit doesn't kick in under Florida law until 2026. So this year and next year, they're still safe under that law. If 2026 comes and they've been on for 8 years, but there's no one else that wants to run, go ahead and try it and see if you can get on. Again, there is a workaround where they drop off and jump back on. That's not ideal. I don't like workarounds to the statute, but then again, I'm a lawyer and that's kind of my job. Um, Thomas Schneider is confused about the 4-hour course within 90 days and the required certification no later than June 30th, 2025. So are all the attorneys in the state, Tom. Sorry. Uh, McKay asked, if a board member refuses to take additional courses, are they removed immediately or by their board at the next meeting? This is a statutory issue, Danielle. So what we're talking about is an automatic. It's not the board decided that you're off because you didn't do what you're supposed to do. It's you're off because the statute says you're off. Um, let's see. Moving on. I'm not sure what Carlton's referring to, so I can't answer that.
That's an interesting
Yeah, not one that I'm going to answer today because it's not um,
related in.
part of what we're talking about. Paul Rosick asks, can you have someone prove food trucks? Yes, you can prove that something's a food truck.
Maybe men provide.
Oh, no, no, no. I think this is a conflict question because the next thing says the boyfriend on the board, the girlfriend's giving free food truck services. If the
Oh,
services are free, there is no conflict because you're not paying the person for the services. So, I mean, you could argue that there is a benefit there in the marketing value of providing those free goods, free services, whatever. But,
well, can I interject?
yeah,
Is if it's like if it's something available that's open and available to the entire community to attend and partake of, is that the same thing as that's not the same thing as a board member taking a kickback for something in return for,
right.
right?
So
Because
if
that's like a food truck comes in, they got to pay for their food. It's available to, anybody could attend. You're not excluding anybody. That's different,
Yes,
right?
that's how I perceive the question. Now, you raise a good point, Jeff. If it is that the board is being provided free food, and it's in exchange for that person being permitted to provide services elsewhere,
Right.
that might be a different story. That might be the conflict that you need to provide. Now, keep in mind, a boyfriend girlfriend relationship is technically not one that's defined in the statute. It's still a conflict of interest, in my opinion, because you've got, I will not go into what type of interest that might be, but moving on. Uh, and I won't mention it because it's not something I will talk about in this type of setting.
Right.
Let's see. If only four individuals run for a five-member board after the four are seated, can a spouse of a board member be appointed as the fifth? If no one else is willing to serve, Chris, then the answer would be yes. What if a city requires a permit for work done on a house inside or outside? Then you would go with the city, Mark, as the hopefully the way of resolving that issue rather than the association enforcing anything. You can report whatever you want to the city.
Mm.
And frankly, I do often find that reporting something to a municipality saves the association a lot of attorney's fees and not having to pursue it themselves.
Mm.
Um, Danielle asks, what if a work truck encroaches on the sidewalk? If that work truck encroaches on the sidewalk and you've got restrictions pertaining to parking on the sidewalk, that restriction is still enforceable regardless of what kind of vehicle it is. So again, that would be one of those secondary violations that I was talking about earlier, where it's not a violation because it's a work truck. It's a violation because it's parked on the sidewalk. So that would still be enforceable, Danielle.
And that's if somebody parks it there overnight. This is not the same as like a vendor coming in to provide work for the association and they want to not have traffic backed up on the street, so part of the truck might be on the sidewalk while the work is taking place. That's different, right?
Depends what the governing documents say. If they only
Okay.
prohibit parking in a certain area overnight, then yes,
Period.
right. If they prohibit parking in a certain area, like some communities that we work with, you can't park on the side lawn, you can't park on the
At
lawn at all.
all.
You must park in the driveway or on one side of the road, and that's it, or in certain designated parking areas. If
Thanks
you're
for
parking on that
clarifying.
sidewalk for 5 minutes, you're still in violation. Whether
Thanks
the
for
board chooses to enforce that violation, given the fact that it's only 5 minutes, totally up to the board.
right. Thanks
Uh,
for clarifying.
yeah, absolutely. And thank you for the addition. Bridget asks, any are grievance and fining committee meetings subject to notice to all owners and open to attend other than attorney privilege? So attorney-client privilege meetings absolutely should be closed. When it comes to the fining meetings, those are generally open. The only notice that must be given is to the people that you're considering fining, but it is open to the members. The committee meetings, I could go on for 10 minutes about whether those are open or closed, and it really just depends what kind of committee it is, how they were adopted. But when it comes to the fining committee in particular, my opinion is that's generally going to be an open meeting, but you can close it off. But it's definitely you need to provide notice and the opportunity to attend, whether in person or by video or phone, to the individual who you're considering fining or suspending.
Hmm.
Let's see. Richard asks, invoices required to be maintained as public records. Does the association only need to keep invoices generated from that day forward, or do they have to post past invoices? If the latter, how far back do they have to go? So that really, my answer is they were always a record pertaining to the operation of the association. They should have always been kept. Now, whether you need to go back and try and find them depends whether you're in a condo or an HOA. That one statute says you got to go back and find these records if they don't exist. The other doesn't say that. That doesn't mean you don't have the obligation. It just means that the statute doesn't say you do. So, it really depends what kind of community you're in, but bottom line, yes, those should have been maintained all along. Whether you chose to do that or not, I can't tell you what your community's done. Jan says, thank you. Thank you, Jan, for coming. Eric asked, do Florida laws require a minimum of 75% approval for proposed exterior color change? Not really what we're talking about, but that's the material alterations that we discussed earlier, and you would want to get with your attorney. There is a Florida statute on point for condos. There's not one for HOAs, but your governing documents might override that, which is why I say, Eric, you're going to want to talk to your attorney about that issue. Mildred, thank you for the kind words. Thank you for the clarification. Erica, thank you. Paul, why can't you see the certificate? We're not sending it out yet. That's why.
Yeah, I'll go over that again soon, everybody. When Alan's done with the Q&A, I'll remain on.
Thank you. We still got about 5 minutes, so let me see if I can blitz through. We've only got 11 questions left so far. Are there any changes that allow the HOA board to spend HOA money making improvements on private properties in the community, such as swales, when the governing document states it's the homeowner's responsibility to maintain swales? My answer is there's nothing that's changed in respect to that in particular. Should insurance policies, Frank asked, be uploaded to the website? It might be sufficient to show that you have the policy number, to simply upload your, I can't think of what the page is called, but basically a 1 page instead of the 100-page policy.
The summary, yeah, the proof.
Yeah. Are all receipts and itemized bills legal records that must be posted on the website of a condominium? They're not legal records, but they are official records, and in my opinion, should be posted on the website. Now, if you don't have those scanned in, you at a minimum, whether they need to go on the website may be up for debate. I think they probably should be. I think the statute says they need to be, but 100% they are now official records of the association. And an HOA, can directors vote by email? No, but they can communicate, Arlene, by email. Again, this is not something that changed.
And Paul's referring to the food trucks when he says she profits.
Yeah, so Arlene, they can discuss by email. They can't necessarily vote by email, but they can potentially, it's not doing it necessarily correctly, but they can make decisions and then ratify those decisions on a later date at a separate board meeting. Or the board can have potentially under Chapter 617 a written resolution adopted by all of the board unanimously that replaces a meeting altogether, which is how some communities do it. Paul, if the individual profits from it, then you've got a potential conflict that you might want to run by the board. Presumably, the board as a whole is deciding that this individual, the girlfriend, is permitted to actually use the food truck and sell food somewhere within the community. I would say you're better safe than sorry with respect to running it by and having the actual conflict provisions handled properly versus not disclosing it, because what you're risking is that boyfriend, just to help out, might get in a lot of trouble. It's not worth it, in my opinion. Whether that would be a successful legal challenge, I don't think so, but why risk it? Denise asks, can a contract proposal be made available at a meeting where the vote would take place, or must it be on the website prior to the meeting? None of the websites need to have that on now, but it will need to be, if it's a board meeting, you would generally need to post that 48 hours in advance. If it's a member meeting, generally you need to post it 7 days in advance. Keep in mind that you don't need to post a damn thing if you don't have to have a website. Paul, thank you as well. Have a great holiday as well. James asked, if the HOA board isn't fully upholding the governing documents, what recourse does the association have? That's one to run by a lawyer. That could be 80 million different things that they're doing wrong. So unfortunately, I'm sorry, but I just can't answer such a vague question right now. Carlos, good to see you, my friend. Thank you very much. Vilma, thank you. Who do you report that the association has their CEUs? There's a website, Umberto, that is run by the state. It's the DBPR, and you can look up Florida CEUs reporting on Google, and you'll find it fairly simply. Marion, thank you very much. And Umberto, thank you very much. James, thank you very much. All right. So thank you to everyone. And we are 2 minutes out. So I will say my thank yous and goodbyes and let Jeff do his thing. So thank you and goodbye. No, seriously, thank you, Jeff, as always, for your help. You're an excellent moderator. I'd work with you any day, but not every day. Uh, and I appreciate everyone for sticking around. We still got over 150 people on, and hope everyone got a lot out of the Q&A. Hope everyone got a lot out of the class. Enjoy the materials. If you've got any questions at all, feel free to email me, find me on LinkedIn, and bother me there. And if you need a new attorney because you're either not happy with your attorney or you just don't have one, hopefully you'll reach out to me. And if you're not comfortable doing that, hopefully you'll click the little box on our form that says have an attorney reach out to me, and whoever's closest to you will be happy to do that. Thank you again for attending today. Again, hope you got a lot out of it. Jeff, thanks again, and y'all have a great day.
Take care, Alan. Thanks very much.